Your doctor refuses to accept responsibility for what happened to you. But now I pick up the phone and call the doctor's attorney. I say, listen, what if we do this? What if the doctor admits liability, admits that he was careless, admits that his carelessness caused you harm and injury, and let's just have a trial on damages? How about that? What do you think the defense attorney is going to say? You want to know the answer? Come join me on this walk on this deserted island here in St. Martin as I share with you that information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, look around you. It's a beautiful day today here in St. Martin. My wife and I are on the French side. My wife is picking seashells. She loves to pick seashells. And now we walked across from that area. It's called Coralita Bay. We walked across. It's a 5-minute walk to where I am now. And this is a deserted island that has only rocks and seashells on it. So she loves this place. And now I have a few minutes to share this great information with you. Can you believe that? I bring my video equipment on this place right here. Well, that's what I love to do, to share this great information. Okay, so here's the scenario. You believe your doctor was careless, causing you significant harm and injury. And now a medical expert confirms that you have a valid basis for a case. So we go ahead and start a lawsuit on your behalf. Shortly afterwards, the defense attorney calls me and says, listen, the doctor believes he did nothing wrong, and whatever he did not cause or contribute to your client's injuries. I say, you know what? That's nonsense. Our medical expert says this is clear cut. In fact, he says, listen, there should be no issue whatsoever. It is so obvious that the doctor was careless and violated the basic standards of medical care. So what do I say to the defense attorney? I say, listen, why don't we short circuit the entire litigation process? There's no need for us to go through 2 or 3 years of litigation where you fight us tooth and nail on liability, on causation and damages. Why don't we just short circuit this, accept responsibility, and now simply have a trial to determine how much money my client is to receive? And you know what the defense attorney says to me? He says, that's not going to happen. I said, but think about that. If it's so clear cut and so obvious that what your client, the doctor, did in this particular case, why would you want to go ahead and ultimately have a jury try and decide that? And he says, you know what, I'll take my chances at trial. And I say to the defense attorney, listen, if the jury determines that your doctor's conduct and his treatment of this patient was so careless, was so egregious, was so outrageous and neglectful, that is going to turn into hate. That is going to turn into anger and outrage. And now they're going to take it out on you and your client. How? By giving my client a much higher amount of money than she might ordinarily receive if the doctor simply accepts responsibility for what he did. And he says, you know what, you have a decent point. I'll have to discuss that with my client, but I don't think that's going to happen. So now, is it going to happen? The answer is you don't know until you actually ask, and each case is different, so the facts of each case have to be looked at critically. The defense will have to go ahead and get medical experts to review the details of this case. And if it turns out that what we are claiming is true, and now the defense has no real defense about what this doctor did and how careless he was, there is the possibility that the defense attorney will reach out to me and say, listen, we've had the case reviewed. Now our medical experts do confirm, yeah, this guy was careless and his carelessness caused your client injury. So that suggestion that you made earlier at the beginning of this case, I'd like to take you up on that. That does happen infrequently. Not often, but it does happen from time to time where the defense will actually come to us and admit that this doctor was careless and caused you harm and injury. But I have to tell you something else really important. Simply because the defense acknowledges and accepts responsibility for being careless and causing you harm does not mean by any sense of the word that they will go ahead and accept the value of your injuries. The defense's goal, once they accept responsibility for what happened to you, their entire goal at that point is to minimize the amount of money that you receive. That's their entire goal. They're not simply going to roll over and accept it and say, okay, Oginski's client wants $15 million, no problem, let's just cut a check and that's the end of it. No, no, no. They are going to try and minimize every single injury that you have and try and show that your injuries are not truly as valuable as we claim they are. And so the litigation will continue, at least on the issue of how much money you are actually to receive. So why do I share this quick information with you? I share it with you just to give you a sense of what really happens in these medical malpractice cases in New York. You know, I do understand you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.